Good afternoon, everybody. Welcome to this afternoon's panel, Responding to Atrocity Crimes and the Security Council's Veto Power, Implications, Realities, and the Future. We've been asked to examine how the international community can respond to the commission of atrocity crimes and uphold the responsibility to protect through other avenues than under a Chapter 7 action taken by the Security Council, given the constraints that have emerged as a result of the veto power. I'd like to thank AZL and particularly the annual meeting organizing committee for the opportunity to moderate what I hope will be a very lively and interesting discussion. We're truly honored to have a set of brilliant panelists bringing to the table years of expertise in the area of atrocity and genocide prevention and accountability. And we look forward to hearing their deeply informed comments about some exciting developments that are occurring in these areas, which may nevertheless leave room for criticism and discussion. I'll just briefly name our panelists now and do further introductions before each one speaks. Mr. Adama Jiang, who has temporarily disappeared from my screen, is the Special Advisor to the Secretary General on the prevention of genocide. There he is. Ms. Ana Perez is Principal Legal Officer, Office of Legal Affairs at the United Nations. Ms. Shahanara Monica is Counselor with the Permanent Mission of Bangladesh to the UN. And Professor Jennifer Trehan is Clinical Professor at the Center for Global Affairs at New York University. Let me first start off with a few brief comments to set some context. I want to begin by reminding everyone that problems with a veto are not new. They have been in place since the beginning of the United Nations. It was only in 1989, with the collapse of the Soviet Union and what seemed to be the rise of democracy in Russia and its satellite states, that the Security Council even began to show some promise of operating the way it had been conceived to. But by the middle of the 1990s, elation about the spread of democracy around the world had given rise to anxiety about the international community's ability to respond to violence occurring within state borders. Violence had broken out in the former Yugoslavia, where the Soviet Union's client Slobodan Milosevic and his Serb supporters had refused to agree to the consensual breakup of the federated state. And the UN's halting involvement did not prevent the slaughter of the very people it was trying to protect. And then the UN's hesitation to commit to action in Rwanda shortly thereafter paved the way for the worst genocide since the Holocaust. When more ethnic conflict targeted Muslims in Kosovo and the Security Council did not act, NATO organized a unilateral military intervention that was at best moral but illegal, and at worst precipitated even more retaliatory killing. And then there was Darfur in the early 2000s. It was out of this context that the responsibility to protect was born. In historical terms, it might be said to have emerged from a sense of remorse and confusion on the part of the international community for its failures during this time. The framework for R2P was set out in 2001 by a report by the International Commission on Intervention and State Sovereignty, the heart of which set out a standard for a humanitarian intervention loosely based on the just war theory. In a nutshell, the doctrine of R2P stipulates that states have the responsibility to protect their citizens from mass atrocity crimes, genocide, war crimes, ethnic cleansing, and crimes against humanity, and that if states fail to uphold their internal obligations, the international community has an obligation to step in. Key features of the ICISS report were adopted by the UN at the 2005 United Nations World Summit. The World Summit outcome document makes it clear that peaceful means should be exercised as a first resort, but it clearly contemplates the use of collective action in the event that peaceful means are inadequate and that nations are failing to uphold their responsibilities. It also commits member states to helping other states exercise the responsibilities to protect. R2P was operationalized in the 2009 report of the Secretary General on implementing the responsibility to protect and put into action for the first time in Libya in 2011 in Security Council Resolution 1973. Controversy about whether the scope of the mandate encompassed regime change led to Russia and China balking at further Chapter 7 actions to prevent atrocities. Since October 2011, they have exercised the veto numerous times, Russia, I believe, 14, and China 7 + 1 abstention, on resolutions meant to address crimes against the Syrian people. During this time, they've also failed, the Security Council has also failed to pass substantive resolutions on the situation in Myanmar. So in this panel, we're going to be looking at some of the workarounds the international community has come up with in light of the veto to help fulfill the promise of R2P. First, hearing about how atrocity prevention is being addressed in the context of the Security Council, as well as some efforts to restrain the use of the veto power. We'll then hear about how other UN organs are stepping up to take action when the Security Council is stymied, and even how the Security Council itself, at least on one occasion since 2011, and with a very specific set of conditions, has been able to agree on a criminal accountability measure. Finally, we will hear arguments that there are actually legality problems when the veto power is used while there are ongoing atrocity crimes, as well as some criticisms of having these alternative mechanisms in the first place. So I'd like to turn now to our first speaker, Mr. Adema Dieng. Since 2012, Mr. Dieng has been serving as UN Undersecretary General and Special Advisor of the Secretary General on the Prevention of Genocide. Prior to that, he had served since 2001 as Assistant Secretary General and Registrar of the International Criminal Tribunal for Rwanda. Before joining the UN, Mr. Dieng was the Secretary General of the International Commission of Jurists from 1990 to 2000, and he was also the driving force behind the establishment of the African Court on Human and People's Rights. For each of the panelists, I'm going to ask 3 questions, perhaps with one follow-up, and I'd like you to keep your answers as close to 3 minutes in response as you can. So Mr. Dieng, for you, question 1, I'm going to ask you first to say a little about your role as Special Advisor to the Secretary General. What is the scope of your mandate, and how do you interact with the Security Council on issues of atrocity prevention?
Thank you very much, Elizabeth. And first of all, let me just remind all of us, as you did, in fact, referring to Rwanda and Srebrenica, that genocide is a process. It does not happen overnight. It requires resources, planning, time, etc., which means that there are signs before the genocide occurs. And when we look into what happened in Rwanda in 1994, we cannot say that we ignore that there were signs. And that is one of the reasons why the Secretary General at that time, Kofi Annan, established my mandate in 2004, 10 years after the genocide in Rwanda, genocide of the. And this is simply to say that my mandate is, my role is primarily collect information regarding violations of rights, which if they are not prevented or halted, may lead to the commission of the crime of genocide. And then once I collect that information, I analyze it, and I do also work closely with a wide range of group partners. I mean, member states, society organization, etc., to mitigate the risk factors. And when it comes, of course, to the Security Council, which is one of the, of course, the government organs we work with, I should say bluntly, that the Council has a central role to play in atrocity prevention. And we have learned, of course, the lesson that when there is a risk of commission of atrocity crimes, or when the crime has already been committed, it is very likely that this will have impact in the neighboring countries in the region. And we have seen it, for instance, in the context of Syria. We have seen it in the context of Rwanda, and we have seen it elsewhere. So this puts simply the situation squarely in the scope of the Security Council, as such situations could eventually lead to threat to national peace and security. But moreover, you made a reference to R2P, responsibility to protect, which which was also adopted as a principle in 2005 as a lesson also learned from the failure of the international community to prevent what happened both in Rwanda and in Srebrenica. And here we have to remember that paragraph 139 of the summit outcome document is very clear, because it refers, of course, it makes specific reference both chapter 6, chapter 8, and of course chapter 7. And we know chapter 7 referring to the use of force. And of course, this displays the unanimous agreement that the prevention of genocide, war crimes, crimes against humanity, ethnic cleansing constitute the responsibility of the Security Council. And it is therefore natural that as a special advisor, I raise my concern with the Security Council. So also would have been natural for the special advisor on the R2P to do the same. But we all know that the Security Council is a political body. Let's never forget that. And as such situations that are relevant for atrocity prevention are subject to the same political dynamics as all other situations which are in the council agenda. So it is very sensitive, of course, to address the situation from this perspective, let alone invite the special advisor on the prevention of genocide or the special advisor on R2P to brief the council on any given situation. So the recommendation, in fact, made by the Secretary General on one of his annual report on R2P remains still to be considered by the council. Invite us brief. But I should nevertheless say that if you compare what the number of times my predecessor briefed the council and the number of times I briefed myself the council during my tenure, there has been a progress. We have to acknowledge it. But yet, it is still very frustrating to see that the council is yet to really make good profit of the presence of the special advisor. And we have simply, of course, to bear in mind that our role as special advisor is to tell the council what it needs to hear, not what the council want to hear. So, and of course, this requires the council to have the willingness to hear, and this is not always the case, unfortunately. And I do believe that the fact that we are observing countries' situation which are being debated within the council, but what is missing is to have a debate using an atrocity prevention lens.
So can I just break in here and ask you, how do you see the council already taking account of atrocity prevention in its actions, even if it's not operating free of the veto power? What are some examples of how you see this?
Well, I would say here that the council, of course, in many instances, has taken action using such atrocity prevention lens. I mean, of course, while controversial, I would say, on account, we have seen the council taking collective preventive action against the Libyan government at the time when the leader of that country, Guy, threatened to massacre his population. And we have seen also the council establishing international tribunals, such as the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, but also we have seen the council referring cases to the International Criminal Court. The Darfur is an example. And this, of course, is highly relevant if we think of accountability as an element of prevention. Also, we have seen the council imposing sanctions against those who were propagating hate speech and violence that could lead to atrocity crimes. And I can refer here, for instance, the situation in Côte d'Ivoire at that time, where the council adopted a resolution listing precisely individuals who were involved. I could have also certainly listed the case of South Sudan, where until I briefed the council in an area formula sitting, there was no action. But from that day, action was taken by the council. And I remember then the US permanent representative at the council saying, no one would say that we did not know. The special advisor has spoken. So the situation here, what is now needed is action. And I'm glad that 6 months down the road, finally, a mission was established, which today is making fantastic work in the field in Central African Republic, despite all the difficulties.
Great, thank you. And could you say just briefly a word about the voluntary veto restraint initiatives and what the value you see in them, even if all members of the P5 have not signed on as yet?
Well, I mean, let's say that there are two Fito initiatives. One is, of course, the one which was tabled, I would say, by France and Mexico, which is a political declaration signed so far by 170 member states. And you have the other one, which is the act, which is led by Liechtenstein and which has now gathered about 103 member states. But what is, I would say, a bit bizarre is that among the 5 permanent members of the council, only 2 of them have signed those 2 initiatives. Naturally, France, first one, promoted that initiative, and United Kingdom. So one may wonder why, though this number is high, why the other states are still remaining waiting to respond. But more worrying, of course, is certainly why the 3 other members of the council are yet to sign that initiative. And to my view, even though they have not yet done so, but the simple fact that this initiative exists sent a strong signal that it is important that we pay attention to prevention. And this is, of course, also one of the priorities of the Secretary General Antonio Guterres. When he was elected, he put prevention at the highest level of the priorities. And to my view, the sole fact that these 2 initiatives are regularly referenced in various fora, including the General Assembly, is something which is very healthy because it leads to bring the debate of atrocity prevention in many forums.
Okay, thank you very much, Mr. Jang. I'd like to turn now to Ms. Ana Perez, who is a UN Principal Legal Advisor in the Office of Legal Affairs, where at the working level, she has led the teams which have worked to establish the 3 non-judicial accountability mechanisms that we're going to be discussing now in this phase of the panel. Before joining the UN, she spent 15 years at universities, including Paris 1, the Sorbonne, Sciences Po, NYU, and the universities Complutense and Autonoma of Madrid. She has a PhD in international law from the Sorbonne. And Ms. Llopis, my first question to you is that each of the mechanisms, and these are the, well, you will just describe them for us, has come into being through slightly different routes. Could you explain those briefly, and also what difference does this difference make in either the form or the function of the mechanisms?
Sure, thank you very much, first of all, for the invitation and for the opportunity to share some views in this panel. So regarding your first question, Professor Wilson, I think that maybe the starting point is just to remind that in contexts where it is difficult to foresee effective judicial accountability, at least in the immediate future, there is, and that's what we have been seeing, there is an increasing appetite at a minimum for gathering and securing information and evidence with the intention in the future to use such evidence by national, regional, and international courts and tribunals that may have jurisdiction over the crimes that have been committed in specific territories. So having that in mind, there have been indeed 3 initiatives these last years, which, as you were mentioning, took different avenues. The first one was in December 2016, when the General Assembly established the International Impartial and Independent Mechanism on Syria, the IIIM, to assist in the investigation and prosecution of those responsible for the most serious crimes under international law committed in Syria since March 2011. This mechanism, as the others, is essentially mandated to collect, consolidate, preserve, and analyze information of violations of IHL, international humanitarian law, human rights violations and abuses, and maybe second main function, to prepare files in order to facilitate and expedite fair and independent criminal proceedings in, as I mentioned, national, regional, or international courts or tribunals. So that was the first one through the General Assembly. The second one came more or less one year later, and this time it was the Security Council in September 2017 that requested the Secretary General to establish another team called the Independent Investigative Team to support domestic efforts to hold ISIL, Daesh accountable for its actions in Iraq. So again, the mandate is similar: collect, preserve, store evidence of acts that may amount to atrocity crimes, but this time major difference committed by ISIL in Iraq. I think we'll get to talk about that later. So just for this brief overview, the third example comes 1 year later in September 2018. And this time it's also another intergovernmental body that is establishing it, this time the Human Rights Council, which decided to establish an independent mechanism, same kind of functions, to facilitate the collection of evidence of crimes committed in Myanmar since 2011, and always with this final intention to facilitate and expedite fair and independent criminal proceedings. So you were asking also about, let's say, major similarities or differences between the 3 of them. I think that as far as similarities are concerned, we can see similarities in the nature and in the scope of these mechanisms. They are all international mechanisms. They are all subsidiary bodies of the organs that establish them, the GA, the Security Council, the Human Rights Council. And regarding the scope, they are all non-judicial bodies, but they still have a criminal accountability scope, as they are going on the short term, let's say, to be collecting, analyzing information regarding atrocity crimes. And on the long term, they are going to be building files to be shared in the framework of judicial proceedings. Also, maybe just to mention in passing, the establishment of these mechanisms seem to reinforce the idea that the main responsibility in the fight against impunity remains with states, which is obviously the rationale also behind the principle of complementarity in the Rome Statute. Regarding the differences, maybe very, very quickly, I think that we could already mention 3 major differences. One is a key one, and let me start with that one, which is the consent of the state on which territory atrocity crimes were allegedly committed. As you know, both the IIIM for Syria and the IIMM for Myanmar were established without the consent of such states, while the third one, UNITAD, was established with the consent of the government of Iraq. I should maybe even mention upon request from the government of Iraq. So this major difference has, I think, an impact and leads to 2 other differences. The first one regards the conditions to operate and is reflected in the terms of reference. For example, if you think about references to international criminal justice, you will find them both in the terms of reference of the IIIM and the IIMM, while this question is silent when you look at the terms of reference of UNITAD. Another maybe consequence. Yep.
I'm gonna break in and try to move you. Thank you. That's very helpful. Maybe I'll skip over the second question and move to the third question. But how have you been seeing so far? What other accountability initiatives are taking advantage of these mechanisms, particularly in the case of the IIIM and UNITAD? Could you just briefly speak to that?
Sure. So regarding, as I mentioned at the beginning, the ultimate scope of this mechanism is to build files to be shared in the framework of judicial proceedings. So, for example, the IIIM mandate, as I was saying, refers not only to criminal proceedings in domestic courts, but also regional or international courts or tribunals. And if you look at the last report from the IIIM to the General Assembly in February 2020, you will see that the mechanism reported that it had so far received a total of 46 requests for assistance from judicial authorities of 10 states. Another question probably is what will be on the long term the utility of the information shared for judicial proceedings. I think we are not yet at the stage where we can assess the impact that the information shared by these mechanisms will have on judicial proceedings. If we think about UNITAD, and the mandate refers this time to criminal proceedings conducted by competent national level courts with the relevant Iraqi authorities as the primary intended recipient, which was one of the major differences I was also going to mention earlier, which is that in this case, it refers to domestic and with the priority for the Iraqi authorities, after there is a general mention to any other uses, which open a door, although any other use should be determined in agreement with the government of Iraq. And finally, if we think about the Myanmar mechanism, I think that there are a lot of novel avenues for the evidence collected, but I understand that the next panelist will be talking about them.
Thank you very much. And yes, I'm going to turn now to Ms. Shahanara Monica. Ms. Monica is counselor at the Permanent Mission of the People's Republic of Bangladesh to the United Nations. She's a career diplomat, having served in the Bangladeshi Foreign Service since 2006, previously as director for the United Nations at the Ministry of Foreign Affairs for the last 5 years, and before that at the Bangladesh Embassy in Washington, D.C. She has degrees in law from the University of Dhaka in Bangladesh. I'm going to ask you first, Ms. Monica, could you briefly describe the role that the member state Bangladesh played in creating the IIIM?
Thank you, Ms. Professor Wilson. First of all, I would like to thank American Society of International Law for organizing this discussion, and I would like to express my gratitude for making me part of this very distinguished panel. I'm extremely humbled. Lopez has already said what is the objective of IIMM and what they're going to do. I would just focus on how it was created. So it was created by a Human Rights Council resolution, which is entitled Situation of Human Rights of Rohingya Muslims and Other Minorities in Myanmar. So it was adopted in September 2018 in the Human Rights Council. And interesting thing is it was tabled jointly by European Union and Organization of Islamic Cooperation, OIC, which actually is very significant because it manifests the strong commitment of the international community to the issue of Rohingya, and it's across regions and across ideologies. So what triggered this mechanism? So basically there were there are many factors, of course, but two major developments triggered this mechanism. The first one was there was a OIC, Council of Foreign Ministers meeting in Dhaka in 2018 May. And in that meeting, the OIC countries adopted a resolution to establish an ad hoc ministerial committee on accountability. And the objective was to address the human rights violations against the Rohingya community. And that committee was eventually formed. And what happened is that it united the OIC countries, member states. And the OIC member states became very strong in the Human Rights Council, also in the General Assembly, and they steered this resolution, which finally established this council. And the second point, and which is in fact the more important point, is which triggered this mechanism is the report of fact-finding mission on Myanmar. So this fact-finding mission, which was established by Human Rights Council again in 2017, in their interim report, which was published in August 2018, it said, and it put out actually some recommendations that there are sufficient information, which warrant investigation and prosecution of senior officials of Tatmadaw in command and its chain of command, so that the competent court may determine their liability for genocide in relation to the situation in Rakhine State. That was what was written in that report. So it actually generated a lot of public opinion in favor of creating some kind of mechanism that will address this accountability issue. And eventually, in the Human Rights Council meeting, the member states came up together and they put forward these ideas in a resolution which was adopted, and it was subsequently endorsed by the General Assembly resolution. So basically it's Human Rights Council and also the General Assembly, they validated this entity. So it is, of course, as Lopez already said, that is, it has the responsibility of collecting evidence and preparing files which could be used by any entity in any international, national, or regional court. And for Bangladesh, the role that Bangladesh played as a member state of Human Rights Council and also UN is we facilitated the work of the fact-finding mission. As you know, that Myanmar did not give access to any of those UN mandated bodies. So it was important for FFM to reach out to the victims who live in Bangladesh, in Cox's Bazar. Professor Adama Dieng had been there. I remember his visit. And also now we provided unimpeded access to all international UN mandated bodies to come and speak to the Rohingyas. And also we, as a YC member and as a member of the UN, we supported and steered the resolutions that were taking place in Human Rights Council and General Assembly.
And what can you speak a little to the question of what other accountability measures this mechanism has led to? It's been some very exciting developments, I understand.
Yeah, I mean, not necessarily this mechanism has actually led this, all these factors that led to this mechanism also led to some other parallel accountability tracks. As you know that there's a case going on in the International Court of Justice under the Genocide Convention, which was filed by Gambia. And this is yet another outcome of the CFM meeting, as I mentioned, in Dhaka, where the YC foreign ministers decided to establish a committee. And that committee actually, after much deliberation, decided to take these allegations to the International Court of Justice under this Genocide Convention. So this is still ongoing. And there's another legal process ongoing in the International Criminal Court. And as you know, the prosecutor of the ICC has opened an investigation over forced deportation of Rohingya people from Myanmar to Bangladesh, and which can constitute a crime against humanity under the Rome Statute. The fact that Myanmar is not a party to the Rome Statute did not prevent the ICC from allowing this investigation, because the crime of deportation actually was completed in the territory of Bangladesh, and Bangladesh is a party to the Rome Statute. So apart from that, you know, there are many options being taken by various governments, civil society, and advocacy organizations to bring these allegations, to address these allegations of atrocity crimes in Myanmar. And there's a proceedings filed by a civil society organization in an Argentine court under its universal jurisdiction, which is again another example of such initiative.
And just briefly, I'm very curious to how has this mechanism affected the situation on the ground in Myanmar with the refugees in Bangladesh? Excuse me.
Well, for us, no, it's a diplomatic issue as well. So we have always preferred a diplomatic solution to this recurring problem. In the spirit of good neighborliness, we always remained engaged with Myanmar, and we'll continue to do so. And however, we know the only viable solution for us to this crisis is the voluntary, dignified, and safe repatriation of the Rohingyas to their own home. However, we understand that we also understand that for the repatriation to be sustainable, the root causes of their vulnerability has to be addressed, and so that they don't have to leave their homes again and again. and situation on the ground has to be made conducive for their return. And the Rohingya people themselves, they want to return, but only when they feel confident about their safety. So we think that ensuring accountability for the crimes committed against them and holding the perpetrators to justice is a critical confidence building measures for their repatriation, which they have time and again expressed. And whether these accountability mechanisms had any impact on the ground in Myanmar is something to be seen in the future, actually. As of now, no Rohingya has agreed to return home, that we know. But in any case, for us, I think as a member of the international community, our respect and commitment to international law and human rights seems unwavering. We'll continue to support any international effort that helps being a sustainable solution to this long-standing problem. Thank you.
Thank you so much. Now I'm turning to Professor Jennifer Trehan. She's a clinical professor at NYU's Center for Global Affairs, where she directs the concentration in international law and human rights. She's a prolific scholar, having authored scores of law review articles and book chapters, and her book, Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, is being published this month by Cambridge University Press. She also recently served as an amicus curiae to the ICC on the appeal of the situation regarding Afghanistan. Professor Trehan, your book coming out now discusses the problem of the veto. Can you explain a little more about what you're writing about?
Yeah, no. Thank you. And thank you to ASIL for having this panel and inviting me to speak. So my book talks about the problem of the veto. And while the IIM was mentioned, and it is one instance when there was a veto and the General Assembly was able to take up the issue, I think we have to acknowledge there are many times when the veto power simply ends the discussion and whatever was being proposed is simply blocked. So there are not always workarounds. And sometimes what the General Assembly creates is less than what the Security Council could have and should have created. R2P, which Adama Dieng eloquently spoke about, of course, can also be so easily blocked by the veto power. And I think when we ask where was R2P in Syria, we have to say it was largely blocked. And unfortunately, he also mentioned the voluntary veto restraint initiatives. And the good aspect is 2/3 of the UN, almost 2/3 of the UN says there's a problem of the use of the veto in the face of atrocity crimes. But as pointed out, 3 of the permanent members do not join these. So we're stuck with this problem, and that's what my book is discussing. Just to quickly enumerate some of the situations historically, going back to South Africa, during the apartheid era, the dismantlement of apartheid was arguably delayed by the use of many vetoes. During the Rwanda genocide, there were no actual vetoes, but there was somewhat of an implied veto threat. The word genocide must not be used, and there was no authorization for added peacekeepers, at least during the height of the killing. Regarding Darfur, Sri Lanka, Myanmar, it is more the veto threat. And of course, no, we're not even talking about a tribunal for Myanmar. And why are we not talking about that? That is because of the veto power. That won't be on the agenda. It won't be proposed at the Security Council. And the veto threat can block measures as effectively as the actual veto, because if a permanent member lets it be known they would veto, it can bring discussions to a complete halt. And regarding Myanmar, there actually was one veto that years ago would have condemned the crimes. And the problem is when years ago, you can't even get out condemnation of crimes, it is somewhat of a green light to perpetrators on the ground, to the country at issue. It has a protector on the Security Council that will shield it. The US frequently uses the veto related to Israel. In my book, I focus discussion more on the situations in Darfur and Syria. And in Darfur, as we see the crimes accelerating, we see sanctions being weakened, we see peacekeeping being weakened, and a delayed, weakened deployment eventually, all the while We have acknowledged war crimes, crimes against humanity, and of course the situation charged by the ICC as genocide with approximately 450,000 fatalities. And regarding Syria, as you mentioned, there have been a disappointing 14 veto of resolutions. They've prevented recognition of crimes, blocked ICC referral, blocked chemical weapons inspections that would have attributed responsibility to the side using the veto, and even blocked humanitarian assistance. So all told, I think the way the veto is being used, we can say it is actually costing lives on the ground.
Thank you. Jennifer, I'd like to ask you, you have 3 arguments why existing law, why there are legality problems with the use of the veto. Do you want to just briefly summarize those for us?
Yes, thank you. So I look at these as 3 separate arguments. So one would only need to prevail on one to make the point. And the first is looking at the relationship between the veto, which is within the UN Charter, and jus cogens. So we say jus cogens is at the very apex of the legal system. So the prohibition on genocide, war crimes, crimes against humanity, we say these are protected by jus cogens. So if they receive the highest level of protection, is it fine to veto regardless of what is going on? And one argument is it is at least inconsistent with this highest level of protection. I also make the argument that in particular situations, the way the veto is used, it seems to facilitate the crimes being committed. It is also a breach of Article 41.1 of the ILC's Articles on the Responsibility of States for Internationally Wrongful Acts, which recognize a duty of states to cooperate to bring to an end through lawful means any serious breach of an obligation arising under a peremptory norm of general international law. So my second set of arguments is looking at the Charter itself. So the veto's within the Charter, but the Charter has certain limits. In its purposes and principles, it says states must be respecting international law, human rights, even just simply the obligation of good faith, and they must cooperate in solving international problems of a humanitarian character. So in my book, I examine veto use, I examine these obligations, and I argue the way the veto is being used is in violation of these obligations. 24.2 of the UN Charter says the Security Council is bound by these obligations, and the permanent members individually are necessarily bound. First of all, states are bound, permanent members are states, but also their whole capacity was created by the Charter. They can't have power beyond the Charter to violate the Charter. That would be ultra vires. And just briefly, my third argument looks at certain foundational treaties, such as the Genocide Convention and the obligation to prevent genocide, and Common Article 1 to the 4 1949 Geneva Conventions, also to some of the protocols, the obligation to ensure respect for the Geneva Conventions. And I argue when there is genocide ongoing or a serious risk of genocide or IHL violations, particularly grave breaches of Common Article 3 violations, the use of the veto is at odds with the permanent members' treaty obligations. All permanent members are bound by the 4 1949. They're all parties to 4 1949 Geneva Conventions as well as the Genocide Convention. And there is really absolute content to this norm to prevent genocide. Looking at the ICJ and the Bosnia-Serbia decision, it is a due diligence obligation based on a state's capacity to influence. Well, a permanent member has very strong capacity to influence, and some of the permanent members also have bilateral relations that put them in a strong capacity to influence. The ICJ also talks about the obligation is not just an internal obligation to prevent genocide on one's territory, but also an external obligation to prevent genocide in other states. And there are similar rulings regarding regarding the Geneva Conventions. In the Wall in Nicaragua case, the ICJ also says these pose external obligations. So I argue the veto in the face of these, at least genocide war crimes occurring, are at odds with these convention obligations. At the end of my book, after also looking at the issue of judicial reviewability by the ICJ of the Security Council, I argue first that UN states should use these legal arguments as much as possible at the UN. They should consider passing a General Assembly resolution recognizing these existing legal limits to the use of the veto, and they should ask the ICJ for an advisory opinion on the legality of veto use while there are ongoing atrocity crimes.
We're getting short on time now, so I just want to break in. I want to give you 30 seconds to make your criticisms that you've mentioned to me about Unitad, because I know you have some strong thoughts.
Yeah, so I'll try to do it really briefly because I know the clock is running. First, we kind of wall standing out of calling these mechanisms accountability mechanisms or not. As Kathleen Marchi-Huel said this morning, they are building blocks to justice. They aren't the justice mechanism. So they still need a part two. They need a justice mechanism. But Unitad, I have some particular concerns in this mandate. It's designed to work with the Iraqi authorities, yet we have troubling accounts of the Iraqi authorities using the death penalty in quick and unfair trials. And of course, then a UN mechanism should not be feeding evidence into such a process. So I think there's a bit of a disconnect there. It is also a one-sided mechanism. And we have this, going back to Nuremberg, where the London Charter says, there's only jurisdiction to prosecute Axis crimes. Well, since then, we've created tribunals with jurisdiction. We don't just investigate one side. So in that way, it also harkens back to Victor's justice concerns.
Thank you. Okay, now we have 15 minutes left. I'd like to give some people, so the other panelists, some time to respond. And then if there are no, I imagine there are some responses, but then we have some questions from the audience. So would anyone like to respond to another panelist's point before we move on to questions? No? Okay.
Yeah. Yes, I just wanted to react to what Jennifer Trahan said when she was concluding her remarks about Unitad. And of course, it was a long process which led to the adoption of the resolution, which established that mechanism. And what I can say, because I visited recently, my last visit before COVID confinement started was in Iraq. I was there and I witnessed the important work Unitad is doing in the field. And I listened to victims, I listened to witnesses, and I think this was extremely important. And I was very moved when I listened to young girls who were abducted by Daesh. All those victims, I went to the University of Mosul. And I think it is important, whatever.
Mr. Jiang, could you turn on your video? I think we can't see you.
Oh, sorry. I was saying that it is extremely important to really make sure that we collect all those evidences which could be used one day. Even if I understand, and I do share her concern, but that was, I would say, the least we could have achieved. And the negotiation takes during a long period. And it started in 2015 when I visited Iraq. Upon my return, I put a paper called Accountability in Iraq with a set of options. And one of them was referral to the ICC, but as she knows, there was no appetite in the council to refer a case to the ICC. And then another one was at least refer specific cases limiting the jurisdiction. Simply to say that I agree, but let's at least continue to support this mechanism because the victims, so far, they are happy with it. And the last point I wanted also is about Bangladesh. I think we should also here bear in mind the extremely important contribution made by Bangladesh. And I personally call it as an illustration of the implementation of R2P on the ground. Because when we speak about R2P, it's not only about the citizens, but it is also about the refugee population. You need to protect those populations. And at a time when Bangladesh opened widely its arms to welcome near 1 million Rohingya, this was something we at the time witnessed when the refugees fleeing Syria to Europe. There were countries which were closing their borders. So we need, therefore, to really commend what Bangladesh did, and we need to continue supporting the efforts of Bangladesh, because there has been tension and between, at some stage, the local population, Cox's Bazar, and the refugee population. So this is simply to say, and I will conclude my last point about the council. The council is also has a role, definitely. If you go back to the 1948 Genocide Convention, and precisely Article 8, any state, any contracting party can contact any of those organs, within the United Nations to play its role in prevention. And the council is logically one of those organs. And I'm pleased to see that for the first time, we had the case brought before the International Court of Justice, and we are going to see how the council will review the report submitted by Myanmar, and that is one positive step. And let's simply say time has come to place atrocity prevention really high in the agenda of the council. Time has come to make sure that provision like the one in Article 6 of the Armed Trade Treaty are also being implemented, which with the ATT, that provision is very clear. Don't sell weapons when you know that this weapon may be used to commit atrocity crimes. So those who are fabricating, producing weapons, please don't sell weapons when you know that this can lead to the commission of atrocity crimes.
Thank you.
Can I react also?
Yeah, go ahead. And then I have a question from the audience for you.
Sure. No, just very, very quickly regarding a couple of points that were made by Professor Trehan. On the question of accountability, I guess it's all a matter of definitions at the end of the day. But I mean, we would all agree that it's not a judicial body, but still, as you mentioned, and Ms. Marcuel apparently mentioned this morning too, it contributes ultimately. And I think that's the difference between one and the other. And regarding the second point specifically on UNITAD, I guess UNITAD has the advantage and disadvantages of what it means to be an instrument that relies on the consent of the state, and that's why I was mentioning that earlier. The advantage, and maybe to be sort of more positive in the approach, the advantage is definitely that having access there, it means that it has the possibility to go in the ground to do some work on some forensic work on mass graves, which I understand has been going on. Also, the direct possibility of interviewing witnesses and victims. So it has some added value, which ultimately, as Mr. Jiang was saying earlier, has the strength of securing evidence, and we'll see what happens. Indeed, there is a big question, and you mentioned it yourself, Professor Trehan. There is this disadvantage of the negotiation with a country on the other side, is that you may not have the ideal mechanism, you may not have the ideal terms of reference that you can do. When you look at the terms of reference for the IIIM and the IIMM, they have all the standards that how we like to have it in there, or the policies drafted in the way we like them to see them in writing, because we did not have to negotiate with anyone. While with UNITAD, we had to negotiate, so any single word it has been hardly fought for. So that was the point I wanted to make. Thank you.
We have a question from the audience about, actually a couple, about whether these initiatives or mechanisms undermine the role of the ICC. Does anyone want to speak to that for a minute or two? Jennifer.
Yeah, no, I don't think they do. The ICC can't do everything. So just that other things are created, they're not threats to the ICC. The ICC deserves our support. The ICC is doing very important work. It's going to do some of the crimes in Bangladesh. It can't do everything. And there has to, so alternative mechanisms are in no way a threat to the ICC. And it will be interesting, the relationship between the IIM and the ICC, and can they actually have a positive interaction and perhaps help the ICC, etc. So I don't think these mechanisms are a threat. They're not operative in situations. As I say, the veto, blocked the Syria referral, so that's why we have the IIIM. So, Elizabeth, if I might just, I'll just take a 2-minute response to. In my remarks, I don't mean to suggest we shouldn't be compiling evidence of ISIL atrocity crimes. I mean, they're incredibly horrific, yes, but I do think there's a real challenge to the international community. How are you going to have these trials done? Through fair mechanisms that don't have the death penalty, because the UN should not be feeding its evidence into a substandard process. And I did see a couple of questions. Am I arguing that the veto is some way causes a state is complicit in the atrocity crimes?
Yeah.
Yes, I am arguing that. That is my argument. I saw that in the chat. And is the Security Council, the question was kind of manipulating the ICC. I mean, the Rome Statute, there is a relationship between the Security Council and the ICC. It can make referrals, and unfortunately it can block referrals. And this is not an ideal scenario, and it's the veto that sometimes blocks very meritorious referrals.
Okay, thank you. I'm getting the light that we have 5 minutes left. So if there is one comment, 3 minutes. All right, then I will add my concluding remarks. I just would like to mention that there are other work being done to think outside the veto, the impasse. And by myself and some colleagues at the International Center for Nonviolent Conflict, we've been trying to think through how civil society could work through this problem. And in my work, I've been arguing that the international community needs to develop a framework for incentivizing nonviolent civil resistance as an alternative means for resolving intra-state political conflicts. Recently, social scientists have shown that, not unexpectedly, military and party-based authoritarian regimes are most likely to commit mass atrocities. But they've also shown, more surprisingly, that mass atrocities are 3 times as common in violent uprisings as compared to nonviolent uprisings, occurring in 68% of violent uprisings as compared to 23% of nonviolent uprisings. So this suggests that the prevention of mass atrocity in the broad schema should encompass efforts to promote democracy, although that's controversial, and incentivize nonviolent resistance. 2 colleagues, Hardy Merriman and Peter Ackman, have tried to think about alternatives to the responsibility to protect that could operate outside of the state-based international system, largely on the basis of a kind of peer-to-peer assistance coming from civil society to civil society inside of nonviolent uprisings. They call it a right to assist, and you can read more about it and the theory behind it in the documents in the chat. I'd like to thank all of the panelists, the American Society of International Law, the ASIL Organizing Committee for this fascinating discussion. I've learned a lot and really enjoyed putting this all together. Thank you very much, and talk to you later.
Thank you.
Thank you. Thank you.
Bye-bye.
Thank you very much.
Bye.